Hi, everyone. Harry here to talk about an important and pretty worrisome opinion from the U.S. Supreme Court that issued yesterday, Thursday, to little fanfare and not all that much notice between its sort of arcane surface, at least, or subject matter, and the flood of other news. All right. We've talked repeatedly about the Humphreys executor case. Hang in there. It's really not that hard. What it is a question of, may Congress restrain the executive to the extent and only to the extent of saying you've got to have some reason before you fire the heads of agencies. You can't just do it willy-nilly. It needs to be for cause. Now, if you think about it for a moment, if you are a big unitary executive hawk, you don't like that rule. You don't like the idea that the president is fettered in any way at all. And indeed, there are at least four, and I would say more, people on the Supreme Court who, for whatever reason, whether for kind of ardor for executive power or just their own reading of the Constitution, have that view. Now, there is an important precedent called Humphreys Executor from 1935. And it has to do with the National Labor Relations Board. And Congress, when it set up that agency, said there are multiple people in charge, not a single leader. And second, this is one of those agencies that the president needs a for-cause requirement. You've got to have a reason, can't just do it willy-nilly. Congress has done that a lot, and in recent years, the court has trimmed back on Humphrey's executor. It has asserted as the primary rule that Congress can't do this sort of for-cause maneuver subject to particular exceptions, Humphrey's executor being the main one. But their analysis has had to do with the number of people up top. Is it a single head of an agency, as with, say, the Consumer Finance Protection Board, which it struck down? And also the question of what level of executive power does the agency exercise? Is it the sort of thing that it really seems to be down the middle, especially prosecutorial, but executive power? And in that situation, the court has trimmed back. Humphrey's executor, however, has remained intact, and the court has made it clear that it's remained intact. So, this opinion doesn't quite kill it, but it decapitates it to within an inch. You know, there's just a teeny bit of viscera standing, but it seems quite clear that they are going to overrule Humphrey's executor. Now, that's bad news in a way, in and of itself, depending on your view, not just of the law, but of American life. A lot of these agencies have these for-cause limitations for two reasons that tend to be pretty good reasons as far as good government goes. One, independence from the political winds of a new president coming in, and expertise, technical prowess that they can use to bring to bear on the often technical regulatory issues that they oversee. All right. There are two agencies that are out there that look to be down the middle Humphrey's executor territory. One is Humphrey's executor territory, the NLRB. So the very agency that the arrangement was upheld in the Humphrey's executor case itself, and the other is the Merit Systems Protection Board, and that has a lot to do with all this stuff that the administration is doing to get rid of people within the federal government, and the argument is this isn't prosecutorial. This is really internal stuff, and there's very good reason for Congress to do this for cause. Okay, so in the 130 days absolute demolition job by the administration, Trump has gone after the heads of these agencies along with others and just said, you're fired. Why? I don't need to give you a reason. You're fired. Now, the courts and in the district court, the Court of Appeals in both these cases, both involving the NLRB and the Merit System Protection Board, said, sorry, Humphrey's executor remains good law. You can't do this. We give injunctive relief. And the administration, in its tried and true way, if you call 130 days tried and true, took an emergency application to the Supreme Court. And the opinion yesterday granted that relief to the administration. It basically said Humphrey's executor is going down. It's just, the likelihood, remember now, we are on an application for temporary relief. So the court says we're not right now administering the coup de grace and overruling Humphrey's executor, but we're predicting that we will, and therefore when you implement the standards such as likelihood of success on the merits, the government is likely to succeed. And moreover, says the majority, there's more of a harm to the government from not being able to remove someone than there is for that someone for now until they decide to lose their job. Okay. The fact of the apparent overruling of Humphrey's executor it's a big honking deal and will revolutionize administrative law, but it was very much expected. And the court's abuse of its emergency docket is something that we're familiar with. But the combination of these two factors in this case is pretty damn nasty, pernicious, even surprising. So what we have is a 2-page opinion, unsigned, per curiam, just simply saying, giving the administration the stay that it wanted, and therefore giving it the immediate ability to fire one of the heads of the NLRB, one of the heads of the Merit System Protection Board, Gwynne Wilcox and Kathy Harris, respectively. They're out now. Okay, what's so bad here? You have a really good dissent that lays it all out by Justice Kagan, who is the administrative law expert on the court. She taught it as a professor. She worked it in the government. She has really still authoritative articles about it. And she says a few things. The number one point she says is, guys, come on with this emergency application stuff. This is a big, important precedent. If you want really to overrule this, it is a disservice to the law, to agencies, to Congress, which created these for-cause provisions, and to the American people to just do it in this unsigned, ill-considered, quick emergency fashion. So that's her number one point. She acknowledges, as almost every Supreme Court watcher does, they were going to take this out. They had their gun cocked and aimed at Humphrey's executor, but to do it this way. So, for 90 years, we've had this good precedent. You've taken it out, and look, you have said, Supreme Court, that all courts, including the Supreme Court, need to take precedents seriously while they are out there until they change. This was the principle that was grievously violated in abortion cases last year, when basically people predicted that Roe v. Wade 2 years ago would be overruled, and therefore you could not apply it faithfully That's just wrong under the law. And until it's overruled, it should be applied faithfully. So that applies to the court. That's Kagan's first point. And her second one is, you guys have your balance of interests all wrong. This is not about the administration's power to supply its person versus the person's personal interest. This is about Congress's interest, the government's interest, the people's interest in having independent folks in these offices. There's real reason why Congress has done this, and your analysis just completely overlooks that part and just, willy-nilly lets the president have his way. And that has an immediate impact. Not just on, it certainly does, though, the Gwyn Wilcoxes of the world, but on us, to the extent that that sort of independence, that sort of expertise that Congress wanted to promote with its for-cause limitations to the president is really something that facilitates sound agency practice in their areas. One more thing. The court basically, in its not even two-page opinion, okay, just says, a really good, strong argument that the that the people for the lawyers for the commissioners who are being fired without cause are making is, if you do this and you get rid of Humphrey's executor, guess what? There's nothing between the president and the Fed, and he can simply remove the Fed without cause. And man, there's no legal difference, but what a disaster that would be for economic management. So they simply say, does the court, the Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. So what? The NLRB also, there's a historical tradition of giving it independence, and really, and this is Kagan's final point in her dissent, it is completely unpersuasive and unprincipled and arbitrary, the way the court just says, oh, but we're not necessarily messing with the Fed. The arguments that they're endorsing in such a summary way seem to take out the Fed as well, and yet that would be, everyone understands, a disaster. But the court's not about disaster. The court's about legal principle. So what happens here? Okay, bottom line. We knew that Humphrey's executor was on the chopping block. We knew that they sometimes abuse the emergency docket and make important decisions without the benefit of briefing and reasoning and argument. There's a way of looking at this that's like, we're in no worse shape today than we were a few days ago. On the other hand, this is by far the biggest victory for the administration at the Supreme Court level, and they do it in this really sort of summary, tawdry fashion. That's bad, and it might also augur more kinds of power grabs by the administration that a majority of the Supreme Court would just acquiesce in. That's bad as well. It still remains the case that, to my mind, the most important thing that the Supreme Court can do, it is doing, that is insisting on its ultimate power to interpret the Constitution, the due process clause. I'm talking about the immigration cases. And, as long as the administration adheres and hews to those rulings, and really all of the courts, then we're not at the sort of ultimate stage of constitutional dissolution. We're already past a crisis point because this is on the table, but of constitutional dissolution. Nevertheless, so that's one way of looking at it. There's nothing that much worse than a few days ago, but the coalescing of what they do in the emergency docket and this really big principle, the way it's done without reasoning, the big power grab it gives to the administration to be able to, basically, I don't see any agency that's safe with the exception of the Fed, and that for puzzling reasons that you can see Leto Thomas or others just hammering at. But can you take a step to the side? Can you imagine if Trump could just put in whoever he wants in the Fed? Just complete economic bedlam. But so that's the bad side, and it's about as bad as it was before. But Kagan's dissent puts it all out there. This was really a bad case to proceed in this summary fashion. They did anyway. That their analysis is tendentious and really in certain points flawed, and it's a very unceremonious death knell, but I think it is a death knell for the Humphreys executor case and all that means for the administrative state. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.